possible. But just to reiterate, just as by way of introduction, my name is Karen Black, and I'll be chairing the meeting. My colleague Robert Seaton, and we're the reporters who've been appointed by ministers to consider the applications for the wind farms at Clash Gour and Rothes 3. Now, I think we're all familiar with the technology. Fingers crossed that things will be running, but if we ask a question of you, you can unmute your microphones. There's also, if you want to say something to us, also just raise your hand and we'll pick up on those points. Can see that all the observers are on, they're not on the screen, so presumably, and it looks as though everyone has their microphone off as well. As before, this is not a live feed. We will be uploading the recording of the meeting to the DPA website in due course. Now, I recognise all the faces on the screens, but perhaps go round again just to confirm who parties that I can see are representing. Can I first ask the Rothes 3 lead representative to introduce himself? Thank you.
Adam, I think you asked for me, Gordon Steele, representing Rothes 3. Can I just add that it was much more difficult in the last few moments to hear what you were saying, and I wonder whether you'd like me at least to turn my video off. Would that help? I don't know, Ewan, if that would help or not.
No, that's okay.
No, Ewan's saying to carry on at the moment, and we'll see how things go. If we get to a point where we do need to do it by audio, we'll proceed on that basis. But if you keep your video on at the moment, that's fine. Did you hear all that?
I heard all that perfectly.
Thank you. The Clash Gour applicant representative.
Thank you, ma'am. Yes, Marcus Trinick, Queen's Counsel, accompanied on this call by David Butterworth of Force 9, Andrew Smith of Force 9, Peter Nesbitt and Kirsty Smith of Eversheds.
Thank you. And for Moray Council.
Thank you, Madam. It's Ewan Brown for Moray Council, accompanied on this call by Aileen Scott from the Council and Cameron Gregg from Morton Fraser.
Thank you. And for Highland Council.
Yes, good morning, Madam. It's James Finlay, Queen's Counsel, accompanied on this call by Karen Lyons, David Moody and Roddy Dowell from Highland Council.
Thank you. And for Save Wild Moray.
Morning, ma'am. Ian Kelly here, representing Save Wild Moray. No other attendees from this group.
Thank you. Now, do we have any representatives for the community councils today? Do we have anyone from Findern Community Council?
Yes, Howard Davenport here from Findern Community Council.
Thank you, Mr. Davenport. And do we have, I see Mr. Hilditch's name, Energising Moray, is that correct?
Yes, Graham Hilditch from Energising Moray, that's correct.
Yes, Mr. Kennedy, I see you're now. Mr. Kennedy, are you taking part in the meeting for Elgin Community Council? No, no. And do we have anyone from Speyside Community Council? Mrs. Ross? No? Okay. And do we have anyone else who's taking part in the meeting? No. Okay, thank you very much. Really just, what I want to do is just confirm the purpose of the meeting today, and essentially we want to really discuss progress towards the inquiry, including the date of the inquiry commencement and the inquiry procedures themselves. So in terms of item 3 on the agenda, the inquiry commencement date itself, we really just want to reiterate our position as we set out in the case conference meeting on the note of the case conference meeting on 2nd of June, and confirming our position that a face-to-face inquiry will commence on the 1st of September, subject to measures to prevent the spread of COVID-19. Now, hopefully you should all have that in your diaries, and that position has not changed. And Mr. Kelly, we received your email about the inquiry programming itself, so we can perhaps discuss that under item 7 on procedural matters when we get to that item on the agenda. And we can also discuss the inquiry venue itself under item 6. Now, we're assuming on that basis, therefore, that the submission deadlines that we've previously agreed as they are as they were, i.e. we have the inquiry documents due on the 4th of August, the statements of agreed matters again on the same date, as are the proposed conditions. Recognitions and witness statements on the 18th of August. So we're assuming that everyone is still okay with those dates, and under item 4 we'll perhaps get an update from each party on progress with those documents. Sorry. Yes, Mr. Seaton's just reminded me that we just wanted to check that everyone is okay with those deadlines for the documents. Now, just if everyone is okay with that, I'm looking for some sign on screen. If you want to say anything, yes, Mr. Steele.
We're agreeable to that, Madam, to save time. Absolutely, yes.
As are we.
Yes, Madam, as is Moray Council.
As is Highland Council.
Yes, ma'am, agreed, fully agreed.
Thank you very much. That's useful to know. In terms of the progress on, first of all, the agreed matters, just looking to, we're seeking an update from each of you in terms of progress on that. So could I perhaps start with Mr. Trinick in terms of, on behalf of the Clash Gour applicant. Have you any updates you can give us?
Yes, thank you, ma'am. We submitted a draft statement of agreed matters to Murray on the 13th of May. We know they've been otherwise engaged. This is not a criticism, but we haven't had a response yet. So we're probably looking to Mr. Brown to tell us when we can expect a response. But additional to that, things may need updating depending on what Mr. Brown tells us about the new LDP. And we know there's intention to adopt this within a week or two, I guess, but that may alter the statement of agreed matters somewhat. As far as Highland Council is concerned, we submitted a draft statement on the 23rd of June. Again, we haven't had a response yet, so I wait an update from Mr. Finlay. Thank you.
Thank you. And I'll perhaps come to Mr. Brown shortly, but Mr. Steele, an update from the Rothis 3 applicant?
Yes, Madam. In light of the circumstances, I'll keep this brief. We are making progress with the statement of agreed matters and agreeing actual matters. In particular, we're hoping that we either have or will agree traffic matters with Moray Council, which would save time at the inquiry. Other matters are progressing, and we, as I simply repeat, I can give you detail if need to be, but progress is being made.
Thank you. Mr. Brown, want to feedback in terms of the council's position?
Yes, Madam. With regard to Clash Gour, the statement of agreed matters, as it stands at the moment, has an appendix which is the proposed conditions. And the way the council has approached the issue is to deal with the proposed conditions first, and comments were made on those as recently as the 17th of July. The intention of the council had been that if they were agreed and when they were agreed, the statement of agreed matters would effectively fall into place, and the council would go back to Clash Gour on those. So matters are in hand there. With regard to the impact of the local development plan, of course, the council will factor that into account and will deal with Clash Gour as appropriate on that. With regard to Rothes 3, the council, as Mr. Steele has said, is waiting for the statement of agreed matters. Draft conditions are in circulation. They were received by the council on the 8th of July. There is maybe an issue which has to be discussed again with Rothes 3 about the traffic issues. The council's understanding on that is that they have been agreed and that they should be dealt with by way of condition, but a conversation can take place separately with Rothes 3 on that particular point.
I wonder if I could.
Okay.
I wonder, Madam, if I could
Yes.
response. Does that mean that Murray Council are withdrawing its reason for refusal in relation to traffic? Because if that is the case, then that may well save time and have an impact on progress. We have not had that confirmation, and indeed we await the return of the draft conditions from Murray Council, and I wonder when that may be.
Mr. Brown, do you want to respond to that?
Well, Madam, it's rather difficult in a video conference to immediately get instructions on that point. What I will do is I will discuss it again with my clients. As I say, the council's understanding is that transport have been agreed. It's a bit of a mystery to the council what the issue is, because both parties have been working towards agreeing and have agreed the transport issues. And indeed, my instructions as recently as yesterday were that a session on the transport issues was not required. The issue is agreeing the conditions, and if the conditions couldn't be agreed, the council's position was that they could be dealt with at a session on the conditions. So I'm rather taken aback, Madam, if I'm honest, that they still thought there's an issue regarding transport beyond agreeing the conditions. And it's not one which can be satisfactorily resolved at the current time.
Well, I'm sorry, it may be my fault entirely, but are the council withdrawing their reason for refusal, or are they not? It's difficult to understand why, if they're in agreement with everything, they wouldn't withdraw the reason for refusal. The difficulty we have is this: thus far they have not said that they will withdraw the reason for refusal. But if it's only a matter of conditions, then surely the reason for refusal should be immediately withdrawn.
I think what I would ask, before you respond, Mr. Brown, I think from our perspective, I think Mr. Seaton and I would, to give you the opportunity to consult with your team, perhaps confirm the position in writing after this meeting.
Yes, certainly, Madam. Sorry, Madam. Yes, I suspect the issue may be that until the conditions are agreed, the objection cannot formally be withdrawn. But I shall certainly take instructions on that, and I will report to the reporters on that.
Could you confirm when that's likely to be forthcoming?
Well, Madam, it depends upon what the council is expected to say. If the conditions have not been agreed, then the council will not be in a position to agree that it's withdrawing its objection to the transport issue. So the formal confirmation that the objection is withdrawn will only follow once the conditions have been agreed, and obviously the input of Rothes 3 is required on that particular point. It's certainly the intention of the Council not to prolong matters, and if the objection is capable of being withdrawn, then it can also formally confirm at that point that it will not require a transport session on it. But understandably, until the conditions are agreed, the Council is not in a position to withdraw its objection entirely. So, Madam, to respond to your question, it should be possible by the end of this week to formally confirm that that is the Council's position, but the question of formal withdrawal of the objection on transport grounds can only follow once the conditions have been agreed, and it's not possible to say at the moment when that's likely to be.
Okay, I think from our position, if we have that confirmation by the end of this week, you said that you would be able to confirm the position in terms of the conditions. Is that my understanding?
Well, what the Council will be able to confirm by the end of the week, Madam, is that the question of formally withdrawing or withdrawing entirely its objection to the transport issue will be dependent upon agreeing the conditions in relation to transport.
Mm-hmm.
But of course, the Council cannot commit to when the conditions will be agreed.
I think rather than prolong the debate at the moment, I think that if you could set out the Council's position in writing, certainly before the end of this week, and we can get, we'll seek feedback. Mr. Seaton and I will consider these matters and obviously allow the Office 3 applicant to have a look at that and respond accordingly. I think it's not something we really want to get into an awful lot of debate about today, but if that's acceptable to you, Mr. Steele, are you happy for us to proceed on that basis at the moment?
Madam, in the circumstances of this call, I think it's best I should say no more. I'm still struggling to understand why the reason for refusal cannot be withdrawn, but there we are. I'll say no more.
Okay, thank you. Mr. Trinick, you wanted to say something?
Yes, I do. I'm none the wiser. I've heard a description of process, but I haven't heard any facts. It's now, we have a deadline of the 4th of August for the statement of agreed matters. We submitted the draft on the 13th of May. We submitted the conditions on the same date. We've had a response on the conditions. We are running out of time. I'd like to know, please, on this call from Mr. Brown, when we can expect a response on the statement of agreed matters so that we can engage in turn and reach a conclusion for submission on the 4th of August. We need some facts here.
Mr. Brown, do you want to respond to that?
Well, Madam, I can respond by saying that the Council is aware of the deadlines. It's working towards meeting the deadlines. It's not trying to avoid engaging with Clash Gour. It has engaged with Clash Gour. It has provided comments on the conditions, as I explained. As far as the Council is concerned, it should be possible to agree the statement of agreed matters within the time frame provided. Unfortunately, I'm not able to commit to a specific date, but inevitably it will be during the course of next week. And my agents will follow up with Clash Gour's agents after this call.
May I just come back, ma'am? I appreciate Mr. Brown can't get instructions on this call, and I have sympathy with him there, but really, when are we going to get this response? Because after we get that response, we need to take a look at it and maybe go back to the Council. It's now the 22nd of June. The deadline is the 4th of August. I think we need something more concrete than that, and certainly some encouragement from the reporters, please.
Yes, I was just going to say, Mr. Trinick, Mr. Seaton and I are in agreement with that view, and I think it's concerning, I suppose, in a sense that we have been aware of these deadlines for well, since at least the last case conference. So I think an urgent response from the Council is certainly something that we would be seeking. on that matter as well.
Well, Madam, if I may reassure you, the Council, as I said, is aware of the deadlines. It is dealing with these matters and it will be responding to Clash Gour.
And can you assure us that the deadlines will be met?
Well, Madam, what I can do is say that the Council certainly endeavour to ensure the deadline is met. It will respond as quickly as it can to Clash Gour. Obviously, Clash Gour then has to respond, but all being well, it should be possible to have an agreed statement of agreed matters by the deadline.
I wonder if I could be so bold to ask, hopefully, that they'll respond to Rothes 3 as well.
Yes, Mr. Steele, there is no issue about that, but of course we're waiting for the draft statement of agreed matters from Rothes 3 at the moment.
Could I just reiterate that if we could get, in terms of both cases, can we get the Council's position, a confirmation in writing of the position before the end of this week?
Yes, Madam, although with regard to Rothes 3, what has the issue there is, of course, that the Council is constrained in what it can say because it's not got a statement of agreed matters. And the other point which should be borne in mind in all of this is that the Council is a public service provider which has been trying its utmost to make sure that public services continue during the pandemic. And the impact of that has been significant for the Council.
I'm not sure I heard you correctly, but you said you don't have a statement of agreed matters, but my understanding was drafts.
No, we don't have a statement of agreed matters from Rothes 3 in draft yet.
Well, to be correct, we're waiting for conditions back, which feeds into it, and we're waiting for a position about traffic, which is a rather important matter in relation to the statement of agreed matters. And I stress again, it really should be easily capable of agreement that the reason for refusal in relation to traffic could be dropped. That would immediately go into the statement of agreed matters, but we cannot get that confirmation. That's the logjam. I've been trying not to take up time, but these are the facts.
Okay, I think, as I say, I'm not going to repeat myself, but I think we'll get the Council, I would seek the Council's position on this before the end of the week. I think that's the utmost of the utmost importance in terms of making progress with the statements, and obviously that feeds into the inquiry procedure itself and the timescales and programming for the inquiry. So if we can seek confirmation from the Council by the end of this week. Sorry, Mr. Seaton is just reminding me. Yes, I think as Mr. Seaton's just asking, if the in terms of the conditions themselves, are they consistent in terms of both cases? Are they likely to be similar for both wind farm proposals?
Madam, I'm sorry to say I'm not in a position to advise on that today, but that will be included in the letter.
Again, if you could confirm that in writing, that would be useful. Does anyone else want to? Mr. Finlay, have you any points to raise in terms of statements of agreed matters, conditions, etc.?
Yes, Mr. Trenick indicated that we'd had in June. We should be able to respond hopefully by Monday of next week, if not earlier. But if I set a deadline of Wednesday of next week, we will have made progress by then.
That's concrete information. Welcome and thank you. No comments.
Thank you very much. Mr. Kelly, do you have any points to raise at all on those matters?
We're not involved in those. We're not involved
in
these matters.
Absolutely. Yeah. Thank you very much. If we can move on to item 5 in the agenda. Mr. Trinick, I believe that the Clash Gour applicant has...
Excuse me.
My apology.
I'd hope to just
yes,
attract...
Mr. Davenport, sorry.
Sorry, I'd hope to attract your attention by turning my video on, but are you expecting, is it appropriate for the Community Council, are you expecting a response on agreed matters from the Community Council? Or is it just...
No, it's not. No, it's not. It's not something that we would the Community Council...
I'm sorry, your voice was breaking up there.
No, it's not something that the community councils would be involved in, Mr. Davenport.
Thank you. Thank you.
You'll be pleased to hear. You will get an opportunity to comment on them. Yes.
Okay.
Okay. Sorry, I have been reminded that the core document list was under item 4 on the agenda as well. Now, Mr. Seaton and I had a brief discussion with the programme officer yesterday, and that is something that she is likely to be involved in. But again, for the purpose of this meeting, just really seeking an update from the applicants and the council in terms of preparing. We put out at the last case conference meeting. We were looking at having a consolidated core document list. So again, if I could perhaps just ask each party to comment on progress with that. Mr. Steele, any comments?
Again, briefly, I believe that progress is being made and that we are working with Clash Gour to get that progressed. Progress is being made, Madam.
Yes, and Mr. Trinick?
Yeah, thank you, ma'am. Ditto. I mean, obviously we're working with Rothers 3 on that. Just one note, though, that the electronic links to the documents are going to have to be inserted after their submission, as I'm told, and I don't understand it, that we will be dependent on the DPEA providing the links once they've received the material and uploaded it. So there have to be a second stage of inserting the links. But that's, I don't think terribly important, but I've been asked to make the point.
Yes, I understand that's the position. Yes, again, we discussed that with Helen Wilson, the programme officer, yesterday, which we'll go on in a bit more detail later in the agenda. Mr. Brown, any comments from the council's perspective?
Yes, Madam. Clash Gour's agents are coordinating that. They've asked for feedback by the 30th of July, and the council's working towards that deadline.
Good. And does anyone else have any comments to make on the core document list? Anyone taking part with that and work on that? No. Okay, we'll go back again to the item 5 that I mentioned. The Clash Gour applicant has an update in terms of the aviation lighting matters. Mr. Trinick, you wish to provide us with the update?
Yes, thank you, ma'am. By the way, you are still dipping in and out of audibility, but I understood the question. We have received a letter from the CAA approving a reduced lighting scheme so that only 3 turbines out of the 20 in excess of, well, of 150 metres or more will need to be lit. There are no objections as such on lighting, and I need to raise with you, and I'm not expecting an answer on this call, but I'm raising the point, the extent to which you believe in these circumstances that oral evidence may become written evidence. Now, I'm not speaking for Rothers 3. I know Mr. Steele has his views about oral evidence, which I don't totally share. I'm happy to revert to written submissions on lighting if you feel that's appropriate, having taken soundings from all parties, and that would save time at the inquiry.
I think perhaps if you could confirm the position in terms of your discussions with the CAA, Mr. Seaton and I will have a look at that and confirm that after the meeting. We'll have a look at the the information that you're going to send to us, and we can confirm that hopefully, well, as soon as possible when we receive that from you, if that's helpful.
I'm grateful, ma'am. We'll do that.
Thank you. No, it doesn't affect the Rothes 3 position, as far as I understand.
Madam, that is correct. Our position is rather different because we have got an objection from the Park Authority in relation to lighting issues. So it is rather different.
Yes, yes. Okay. So, Mr. Trinnick, you'll confirm the position as soon as, presumably, after this meeting.
We'll do that today, ma'am.
Thank you. That's helpful. Thank you very much. Now, Mr. Seaton and I are just changing microphones, obviously, because we've got the audio problems. So if you bear with us just a minute or two, we'll transfer the microphone over.
Right, so I hope by now you'll have seen the note that we issued in respect of inquiry venues. This is item 6 on the agenda. In brief, we take the view that we remain at a dangerous stage in the pandemic, and having taken advice within the Scottish Government following the move to phase 3 of the release from lockdown, we're of the view that we should hold the inquiry in a venue which can provide the assurance of already having a safety assessment in place and operating. And for that reason, we've decided to accept an offer from the McDonald Hotels in Aviemore rather than the Elgin Town Hall to hold the inquiry. Now, I put this on the agenda because I imagine some people might have want to make a comment on that. So does anyone want to make a comment on that at this stage?
Sir, if I may, on behalf of the council, make a comment on that. I appreciate that given the nature of the pandemic, decisions cannot be fixed and that decisions have to be made quickly. But we obviously received this email last night at 5:30, and I've only had an opportunity to have some preliminary discussion with the council about the change of venue. The council's immediate reaction is that it's very concerned about the change of venue and indeed disappointed that Elgin Town Hall is not thought to meet the criteria. It's appreciated that ultimately it's a matter for the DPEA, but the council is, as I say, very concerned about it. The distance between Elgin and Aviemore is 46 miles each way. It's a journey time of 1 hour and 10 minutes each way. That's obviously significant. It's significant for the council, and indeed, in the very brief discussion which I've had with my clients today, I think it's appropriate to flag up that they may wish to proceed by way of written submission. Now, the administrative burden is significant for the council being expected to make that journey, and the cost for the employees who are expected to make it is also a factor which has to be borne in mind. More than that, as was said at the last case conference, this is these are applications which have generated significant public interest. The council anticipates that members of the public will want to be involved, and there is a risk that they will be cut out of the process if the inquiry is held in Aviemore. And it's appreciated that arrangements can be made to have the proceedings webcast, but of course there will still be those who may have difficulty accessing the internet to do that, or indeed have the IT equipment necessary to do that. So if the DPEA maintains its position that this inquiry should take place in Aviemore, thought should at least be given to how the proceedings can be relayed to a local venue which is readily accessible to members of the public who wish to participate and see the proceedings take place.
I wonder if I may respond to that, if you'll allow me.
Yes, of course, Mr. Steele. Yeah.
Thank you. Firstly, we support the move to Aviemore for a variety of reasons, some of which have been set out in earlier emails. But if the advice that you have from your health and safety advisors is to the effect that Aviemore is to be preferred, I would submit that is an end of the matter. That's where we must go. Moray Council have raised the issue of written submissions, that they may proceed to written submissions. Well, my submission on that is that that would be wholly unreasonable. This is an inquiry which may well be decided on landscape and visual issues and credibility and reliability of witnesses. I submit that we are entitled to hear the evidence from the council and, more importantly, to cross-examine it and to test it. And it would not be appropriate for them to opt, nor would it be consistent with the law for them simply to go to written submissions. That would not be legal or appropriate. Separately, I take the point and hear the point about members of the public, but that and lack of access to internet, webcasting, etc. But that matter is easily resolved by installation of one or more screens in Elgin Town Hall to which the inquiry is beamed live. And it wouldn't even need to be in the main hall, but for reasons of cost that may come into it, but there is a related lounge bar area and or a dining room area in which these screens could be erected, which would no doubt accommodate members of the public who could not otherwise watch it at home, thereby removing any difficulty for members of the public.
Does anyone else want to comment? Mr. Trinick.
Yes, thanks, sir. We're entirely content with Aviemore. We were happy with Elgin. We'll go over tongue, frankly. Right. I do understand what Mr. Brown says. I have two questions. Firstly, at Aviemore, which room? Are we talking about the big reception building, the modern building, rather than the old hotel further up the hill? I hope we are talking about the modern reception building. Secondly, did I hear Mr. Brown right, that the council would revert to written submissions?
Mr. Trinick, on that point, I said that this is the intimation of the change of venue arrived late. I've not had a chance to consult with the council on that. That will be done after this call, and a decision will be made. But I was flagging up that that may be a possibility for the council. I thought that was only appropriate.
Okay, noted.
Does anyone else want to comment? Nope. Okay. So on the issue of where it would be, it would be either it would be in the reception building, so it would be in the Osprey Suite or the Peregrine Suite in McDonald's Hotels. Which venue hasn't been finalised, but it'd be in one of those two. Mr. Trinick?
I said understood, and that's good. That's a tick in the box for me.
Okay, good. The other points about the access of the public. Yes, it will be webcast. I was going to come on to this in relation to procedure later on, but our advice is that we should be excluding the public so far as possible from the inquiry. What I would propose to do, or what we would propose to do rather, is that we would offer an opportunity for the public to attend on application, and that if they could give a reason why they should attend. Otherwise, we wouldn't include the public. We would rely on the webcast of the inquiry for the public to be able to view it. I understand the points about the difficulties of webcast, and that's why I think we should allow the public in, or some members of the public in, if they have a reason to attend. But I think we're we're in a situation where, as I said, we're at a dangerous phase. We're looking at currently at an outbreak in a call centre, and the Scottish government doesn't want an outbreak anywhere. Least of all in a situation where the Scottish government is in control. So I hear Mr. Steele's suggestion about having a screen in Elgin Town Hall, and it undoubtedly has some attractions. My concern would be, I will take it away and have a think about it. We will do. I think my concern would be that, again, it would be a space in which we would be encouraging the public to come together, to do something together, and that's where I would have concerns. As regards the Council's concerns about attending the inquiry in public, well, I will await the Council's submissions on that. I'd be grateful if you could respond in writing. I absolutely appreciate the decision was issued late last night. I understand the Council's position on that. I think it would be difficult to take landscape and visual evidence by written submissions, given the state we're at, and given the position that we are holding a public inquiry and with cross-examination. I think perhaps as regards other evidence, we could perhaps look at the availability of a video link. We certainly are proposing to take evidence by video link where people are quarantining. So that's perhaps something we can consider. Okay. Does anyone have anything else on this?
Sorry,
Mr. Steele's disappeared.
Yeah, I clicked the wrong button. I'm sorry, entirely my fault.
Right.
A question in relation to landscape and visual. I've heard what Mr. Brown has said, but I thought Moray Council had 2 landscape independent consultants who don't actually come from Elgin itself. I just wonder, therefore, what the difficulty is about them attending in Aviemore, which actually might be closer to where they come from. So I'm not sure what the logistical difficulties are.
The issue, and I'm sorry if this wasn't made clear, sir, the issue is the additional financial cost and of employees from the council having to travel from Elgin to Aviemore every day. Now, sir, as I indicated, I was flagging this up because it is a very serious issue for the council. It's just been thrown at them last night. It has to be taken away. It has to be considered. There's a consultation which will take place immediately after this call on that very point, and the council will confirm its position in the letter which is to be sent by the end of the week.
Yeah, well, thank you, Mr. Brown. I don't think we got a response there about the position of the consultants and indeed yourself. I don't really understand why there would be additional costs.
So the additional cost comes through the direct cost of the employees from the council who have to be involved in the inquiry having to participate. It's not the cost of myself or my agents or the landscape visual impact experts. It's the direct cost to the council, which is obviously a significant concern given the current stress on public finance caused for various reasons.
I understand. I'm sorry, Mr. Brown. I didn't mean to interrupt. I mean, I understand the position the council's in as regards both as regards responding to this and as regards the distance from Aviemore to Elgin. I don't want to draw this out, but what we've said is that we will have a live video feed. We are assuming that people will, or we're not assuming, we want to instruct people not to be whispering to each other within the inquiry hall because we need to observe social distancing. We expect people mostly to be communicating by electronic communications. In those circumstances, and perhaps you can take this away to the council, we don't necessarily see a difficulty with council employees being, people in a position to give instructions, being at a place remote from the inquiry venue. But I've no doubt that that's something you'll want to respond to, and I'm not pressing you for a response to that just now.
Yes, thank you, sir. I think it's appropriately dealt with in correspondence after this call.
Okay. Mr. Kelly.
It's only 6 weeks to the inquiry starts, and normally I'm one that argues very, very strongly for a local venue. But in the circumstances here, as I've said before in earlier emails, biosecurity has to be the prime consideration. But in terms of the practicalities of booking accommodation, can it now be agreed that whoever's participating, the inquiry will be in Aviemore?
That's what we've said in our statement, Mr. Kelly. Yeah, I don't think we have the option of holding it in Elgin Town Hall. It's a decision we've taken with, as you can see, with considerable reluctance. But I don't think we have the option of doing that. Okay. So we've covered a number of the issues, or at least in outline of that I'd wanted to cover in the next agenda items. We issued a revised agenda yesterday, along with our note. So I hope everyone's got the revised agenda in front of them. Item 7 on the revised agenda is procedural issues, under which there's a number of bullet points. The first of which is the number of attendees for parties. Now, this is an issue that's come up in correspondence. We've had a fairly helpful comment from the Rothes 3 applicant that they can go down from their proposed 6 to 4 people attending the inquiry in person. We've also had a comment from the Clash Gour applicant that they may need more than the 3 that they'd proposed. I think we're in a position where we want to have the minimum necessary in the inquiry room, and as I said, the inquiry is to be webcast live. We certainly don't want people to be in a position where they're either encroaching on safe distancing by whispering to each other or passing notes. We want people to be using remote electronic communication. So from our point of view, we think that a number of these proposed attendees can be outside the room or the inquiry room itself. We don't really see an absolute need for having any more than the witness for that segment of the inquiry and the advocate for each party in the inquiry room. It seems to us everyone else can watch the inquiry remotely and give instructions as necessary. And we can, of course, discuss with the proposed programme officer how we can use the timetable to limit people in the inquiry room. But our basic point of view is surely we can manage fewer people than the 6 proposed by Moray Council, and even the 4 proposed by the Rothes 3 applicant. Can we? I'll take comments on that.
So for Rothes 3, sir, we'll do everything in our power to minimise attendance, not at least because it's in everybody's interest. Now that we know that the venue is fixed at Aviemore, it will assist us because we will also book a conference room for ourselves, probably in the same building if it's available or close at hand, and we will be able to locate 1 or 2 people in that room out with the inquiry. In terms of what that means for precise numbers, there will be occasions on which we will have 2 or 3 witnesses on a topic dealing with landscape and visual. I wouldn't like to commit myself to a precise number of only 2 just at the moment, sir, but everything will be done to minimise. We are fully aware of the difficulties.
Okay. Well, what we can perhaps do is, well, I think we'll take everyone's comments. Sorry, Mr. Trink, I'll take you next.
No, thanks, sir. That's fine. The 6 would only ever be needed if we were dealing with lighting evidence orally, because we have 3 witnesses and I would want them, I need them there at the same time. Apart from lighting, we could probably get away with 3 in the room, or at the most 4. But I would ask that you make provision for, say, 4 people in the room at one time from our side.
I'm sorry, 4 or 6?
4.
4. Right.
But if lighting is to be dealt with orally, then I need 6.
Right. Sorry, just before going to others, I assume that I think that the lighting issues for Clash Gour and Rothes 3 are sufficiently different that the lighting witnesses for Rothes 3 wouldn't need to be in the room at the time that the lighting witnesses for Clash Gour were in the room.
Well, sir, in relation to the aviation, precise aviation lighting point, I think the issues are, if not identical, very similar indeed. That is not to say that our witnesses will have to be in the same room. It may be they can be in our conference room just behind the main room, if you follow me, but not terribly far away. But I repeat, we'll do everything in our power to minimise, once we know exactly where we're going and exactly what the setup is. We have no intention of having too many people there.
Right. Okay. Well, I think we can work with the program officer on issues like that. Mr. Brown, I'm sorry, I'll go to you next.
Thank you, sir. Yes, the council is acutely aware of the fact that it's not prudent to have too many people in the room at the one time, and it will certainly do what it can to minimise that. The figure of 6 was a maximum figure for the purposes of space planning, because it was anticipated that there may be a requirement for that number in the room, bearing in mind that the council has 2 landscape experts. However, as I say, the council will bear in mind the desire to keep the numbers to a minimum and will do that wherever possible.
Yes, I should have said, I mean, I understand that where there's two witnesses for a particular segment, it's simply necessary for them to be there. Yeah. Mr. Finlay? Can you hear me, Mr. Finlay?
My apologies. Yeah. Just clicked the wrong button. We would hope to limit it to 3 at most, probably 2 in the inquiry most of the time. But if my witness is giving evidence, it may be then 3. But so 3 maximum.
Right. Why is that? Why would you need 3 while the witness is giving evidence?
Well, the witness, myself, and one other who may to potentially assist whilst that witness is giving evidence. I hear what you say about electronic communication and the desire to avoid persons whispering in close quarters to each other, but there is the ability for someone in physical proximity, albeit 2 meters away, to assist in terms of documentation and seeing what is happening at the inquiry. So it may not be necessary, but I would indicate that, in my view, 2 should be possible most of the time, but the 3rd, when I am cross-examining or when my witness is being cross-examined.
Right.
If I may, I completely agree with Mr. Finlay that if you're an advocate of one of these inquiries and your witness is giving evidence or you're cross-examining, it is exceptionally helpful, indeed necessary, to have that third person there to assist when required. I'm constantly asking people for help during these exercises to get me a reference or to get a document.
Right. I have to say, we were hoping to keep actual document handling to a minimum. I understand that some documents need to be physical, but would that assistance be also with electronic documents, or is it physical documents you're thinking about?
Both.
Both. And if I can say, it's more obviously it's alerting. It's not just document handling, but it's alerting to what may be in a particular document, or what document you should be looking at, and the ability to do that whilst listening to someone cross-examining your witness, and whilst trying to keep a note. The smooth run of the inquiry, to my mind, would be assisted by that, and it shouldn't take up too much extra space, and we should be able to accommodate that with being COVID safe. I would say that I've done a virtual hearing before Mr. Jackman, where the witness and I sat in the same room, but 2 meters apart, with some support behind us. And that proved very effective in presenting our case, or at least I hope it did. But we were able to maintain social distancing throughout, but it made a significant difference. It's that experience which, to my mind, makes it almost essential that there is the ability to communicate, if possible, during the course of inquiry.
Right. Okay, does anyone else want to make a comment on this? No, Mr. Kelly, no. Nobody else. Good. Right. Well, we'll take that away, and we'll have a consider. We'll consider how we'll deal with that. It would be helpful. I think the program officer is if appointed, is going to help us with an inquiry program, and that will help limit, hopefully, the number of people at the inquiry. Yeah, I think it's helpful also to have the explanation. I think we will, as regards having a third person there at the inquiry, we will take that away. I think what we want to do, I was going to come on to this, but was produce a protocol of how we expect the inquiry to run as regards COVID-19 safety. So we would consider the number of, who should be in the inquiry room within those rules. Obviously, we'll consult those rules with the parties before we impose them. Now I've set out when in discussion on an earlier item, the question about presence of the public. Just to remind you, our view is that we would put in the advertisement for the inquiry that people can apply to us if they wish to come to the inquiry. Otherwise, we wouldn't want the public to be there. We would exclude the public if we haven't specifically accepted them and they have a reason to be there. Our view is that otherwise people can watch it on the webcast, and if they have severe difficulties with broadband, well, they can come to the inquiry, and that may well be a good reason to come to the inquiry. Does anyone have a comment on that?
Sir, if I may start, hear all of that. I'm just slightly concerned if there's members of the public who cannot reasonably travel to Aviemore and don't have broadband connection, and there will be some of those undoubtedly in this geographical area because of the connection issue, but that matter would be solved simply by putting a screen in Elgin Town Hall. I hear exactly what you say. You don't want too many people there, but it's a big room and there's lots of space, and who will turn up, of course, is another matter, but at least that would solve any possible complaint.
If I may?
Mr. Kelly. Oh, sorry, Mr. Trinick. Yeah, and I'll come to you, Mr. Kelly. Sorry.
Sorry, Mr. Kelly, I cut in there. I think the way forward, sir, may be for you to seek some confirmation as to who actually wants to come to the inquiry. You can do it through Mr. Kelly, who has some more local information, or otherwise. But you need to get some idea of numbers. I mean, if there are very few people, that's one thing. If there are hundreds, that's another. I would suspect that there are actually very few people who want to come simply and observe as opposed to participate. But it would be useful to get some numbers on this.
Mr. Kelly.
I think your idea of making it clear in the advertisement the procedures that will apply is a good one. I suspect, I'll check with my clients, I suspect that not too many people will wish to travel to Aviemore for a number of days of the inquiry. I suspect that there would be more interest in coming to Elgin Town Hall to view a large screen. I think in the circumstances of the social distancing being applied and limitations on large gatherings, I think even the Elgin venue might not attract any more than 20 to 30 people on the first day with declining numbers. I can check, but I think the most important issue is to make it clear in the advert of the advertisement of the inquiry what the procedures are. And we're in difficult circumstances and we just have to adapt to them. But I will try and help with numbers if I can.
Well, that would be extremely helpful if you could get back to us on that. That would be very helpful. Just so we have an idea of what numbers are. Okay, would anyone else like to come back on that? No. Yes, so the outcome of that, I think, is, as regards your point, Mr. Steele, I think that the way we would address it is by putting it in the advert, simply making the invitation in the advert. And we will see what numbers are from the responses to that. But it'd be very helpful if Mr. Kelly could give us an indication beforehand if there's going to be lots of people. Yeah. Okay. The next point is the inquiry timetable. I know that Mr. Trinick wanted to say something about this. What I would say at the moment is we will produce an inquiry timetable. Our original idea was to produce it after the submission of documents. We've had a discussion with the proposed program officer, and she has offered her assistance with that, which we very much appreciate. That's as much as I'd say at the moment. I think I mentioned that we think we can use it to help limit numbers in the hall. Mr. Trinick, you want to say something on this?
I think I've already said it, sir, in another way. It's about how to deal with landscape and visual evidence and lighting evidence, because Mr. Welch, as you know, is not available in week 2 of the inquiry, and we were getting a bit exercised about how to balance this out. But I think I'll wait for you to come back to us on what you want to do about the lighting evidence. That may resolve the position.
Right. Okay.
Can I just?
I think
can I just say on?
Yeah,
I had raised the point of the timetable from a very simple, practical view, and that is looking at the cost of accommodation in Aviemore at the centre. I was wanting to know if we're looking at booking 1, 2, or 3 weeks accommodation. Quite significant differences. Looking at the state of the evidence, I formed the view that the inquiry could reasonably take place in 2 weeks, especially with a Monday to Friday in the second week. And I wasn't really seeing the remaining need for a third week. But I think in terms of just the simple practicalities of booking accommodation, we need to have an indicative timetable as soon as possible. Thank you.
Mm-hmm. Okay. Well, thanks, Mr. Kelly. I'm sorry, I had noticed your very helpful suggestion earlier. I'd mentioned this at the previous case conference. I wondered whether we might reduce the inquiry to 2 weeks. Obviously, Mrs. Black and I have to come back on the aviation evidence, and we're to hear about whether there'll be agreement on the traffic question for Rothes 3. So I don't know whether anyone wants to make a comment on whether the inquiry can be reduced to 2 weeks just now, but perhaps it's a point we can bear in mind for the future. Mr. Trinnick's concern, of course, is about Mr. Welsh's availability in the second week of September. Yeah, we may end up in difficulties if we try to sandwich the inquiry into 2 weeks. If those 2 weeks end up being 2 weeks with a week in the middle apart, if the landscape evidence were to overrun 1 week, the first week. I'm sorry, I'm being a bit garbled, but perhaps I see Mr. Trinnick's wanting to speak there.
Well, I think that we ought to keep to those 3 weeks, because I think that the landscape and visual evidence may go on some time, and there is a possibility of overrun. Equally,
right,
we don't yet know the consequences of the special arrangements we're having to make for the time that it will take to hear oral evidence, especially if someone, for reasons we can't foresee now, has to be heard by video link. There are some uncertainties here. I'd rather not interfere with the 3-week program at the moment. The issue about Mr. Welch, we've made this clear for a long time. He's not available in week 2. The issue would arise if we dealt with landscape and visual evidence and then turned our attention to aviation lighting evidence, because Mr. Welch might well be pushed into week 2 on that basis. But I fully agree with your proposal that, I think it's your proposal, that the programme officer, if appointed, should get to grips with this pretty quickly and send out a draft timetable.
Yeah.
Just to indicate from
Mr. Steele.
Thank you, sir. From our point of view, I do not think it realistic to think that all of this can be shoehorned into 2 weeks, not least because of arrangements that may have to be made for to do with social distancing, time between witnesses changing over to disinfect desks, so on and so forth. But I would think it realistic to suggest that landscape and visual will not conclude in week 1. That includes, of course, our lighting evidence. We've got 2 witnesses on lighting and also a landscape architect, and there are several cross-examinations, and it may be there's 1 or 2 questions of clarification from a couple of parties, and no doubt Clash Gour have got something similar, witnesses from others. I think it's just unrealistic to think that's all going to finish in week 1. I thought we'd also agreed, again, I think it's realistic to timetable with certainty week 3 for the planning policy evidence and conditions and the likes. And we still have a number of other issues to be dealt with in week 2. Traffic may or may not be live. Ornithology is live. peat, economics. And that's both from us and to some extent from Clash Gour. I cannot see all of that being concluded comfortably in 2 weeks. And I think we should be sensible about it. Timetable planning for the 3rd week, come what may, and the rest can be dealt with during week 2. If it so happens we've got an afternoon off, so be it. I think that's a lot safer than running out of time and then having to try and fix things afresh.
Yeah, Mr. Steele is reminding me of a point that we have discussed about programming, and that's that it would be very useful to have a very clear and fixed program, which doesn't involve people waiting around to come into the inquiry, just from the point of view of limiting the number of people gathering either in the inquiry room or outside. Mr. Kelly, though, would you like to come back on that?
Thank you, sir. Yes, myself and my clients will be okay if you stick with the 3-week programming, with the proviso that policy will only be heard in week 3. That would still let me avoid booking accommodation for week 2. It's just that I wouldn't like to book accommodation to avoid week 2 and then find there's some landscape evidence there. So if the spillover of landscape evidence given Mr. Welsh's availability was to week 3, then that's fine. And if policies in week 3, that's fine. It does allow me then, with that programme, to skip week 2 and not incur the cost of accommodation in week 2. So I would be happy if you stick with that programme.
Okay, I appreciate that these things will be discussed in detail by the programme officer. Does anyone have any concern about that particular suggestion by Mr. Kelly?
None at all, sir. I completely support it. But I would point out this, that it may be that it would be our case rather than Clash Gour, which may spill over. And whether Mr. Welsh would have an interest in that or not is another matter. I suspect and hope not. And that would remove that particular issue, which is the way that we have been looking at it, because Clash Gour are going first. I would imagine their entire case will resolve within a couple of days or so, and certainly not beyond week 1 on landscape and visual.
All right.
So can I just mention from Highland Council, we assumed we'd probably, although we're only concerned with Clash Gour, that we'd have to be there for most of the landscape evidence. And if it's not, it would be very helpful to know for certain that if there was any run over it, it would go to week 3. At the moment we planned on it being in week 2. Certainly I will take instructions, but I'm certainly available in both weeks. And it would only be,
right.
If it did go into week 3, it would be for the first 2 days in week 3, it would be contemplating it overrunning 2. It would be useful to have confidence as well.
Sir, if it's only our case overrunning, I don't think Highland Council would be interested. I'm sure they'd be interested, but wouldn't be concerned. And nor, I hope, would Mr. Welsh. So I'm not sure that that would be an issue.
Well, absolutely. It depends. As I understood it, we're going to hear Mr. Chinnick's case first, then Mr. Steele's, and then have the opposition to it. And it may be that the opposition doesn't come until week 2, but that may depend on how the inquiry is formatted. If Clash Gour is completely finished, then we wouldn't need to be there for any potential overrun, but we can't rule that out at this stage. So that's why I'm saying that it would be useful to have certainty as to when any overrun might be, so it can be at least provisionally.
So that may be my misunderstanding. I thought we were going to have the Clash Gour evidence and the opponents of Clash Gour first before our case even started. I thought that's what had been discussed and agreed, but
no.
Right. Well, in that event, what I've said earlier is wrong. But in that case, I would propose that Clash Gour should be dealt with first, and the opposition to Clash Gour first, in order to avoid the procedural, practical difficulties that have been referred to.
I'm staying silent on this. I want to see a draft programme before we discuss matters further.
Okay.
And I want to hear your views on the lighting evidence. That's what's going to make the difference to week 2 so far as we're concerned. I'll ask one question though, through you to Mr. Finlay, and that is that if all that's left of Clash Gour at the end of week 1 is lighting evidence, does Highland Council have an interest in that evidence? My understanding is not.
I can't give a direct answer to that, but I would ensure that Mr. Chinnick has an answer to that within a week.
Thank you.
Okay. Right. Well, I think that takes the discussion as far as we can take it. It's been very helpful, but we'll get the programme officer onto that. assuming she's appointed, which is sounding like everyone's content that she will be, but perhaps we can, I think that's, where have we reached? Oh, before I can discuss the programme officer, yes. The question of views on whether to hold an evening or public session or written submissions. I think we covered this in the last case conference. We remain of the view that an evening session can adequately be replaced with an opportunity for individuals to make written submissions at a point at the end of the inquiry. Does anyone have any concerns or doubts or disagreement with that? I'm looking to Mr. Davenport as well as everyone else here. Mr. Davenport, do you have a concern about that in particular? Oh, you're still muted, Mr. Davenport. You'll need to
there we go.
yourself. That's it.
Yeah, just finding the buttons. I'm not sure. In ideal circumstances, I think an evening session where the public, members of the public could get a feel for what's been going on, etc., would be the best way for people to put their points across and get involved. However, in this pandemic situation, we may need to think again about that. So I'll have a chat with my colleagues and get back to you.
Yeah. Mr. Davenport, before we move off you, I'm sorry, I'd asked Mr. Kelly earlier to gauge how many people might want to come to the inquiry in person. It would be helpful if you two could gauge that and come back to us as well, if you're able to
I made
get
a note
view
of that.
in your local area. Yeah,
I made a note.
Thanks very much.
Okay.
If the other community councils, Elgin and Speyside, if they're watching this, if they could also come back to me on that, that would be very helpful. Sorry, going back to this point about evening session or public session, does anyone else have anything further to add? Mr. Kelly?
Yes, I've taken specific instruction on this in the context of the COVID-19 restrictions, and also with the inquiry venue now being Aviemore. The view of Save Wild Moray is that in these circumstances, written submissions would be the appropriate course rather than an evening session.
Good, that's very helpful. Thanks, Mr. Kelly. Okay. I was passing on to any other issues arising from measures to address the COVID-19 pandemic. Just briefly, we touched on the issue of documents at the last case conference. Again, I simply reiterate that we would discourage, we understand that paper documents will be necessary in the inquiry to an extent, but we'd encourage parties to minimise them as far as possible. We won't be providing a public set of paper documents, but we will have a tablet available with documents on it which can easily be cleaned. The programme officer has indicated that she would be able to help with presentation of documents at the inquiry, so that documents can appear on a screen while the evidence is being presented, which I think would be very helpful. And the documents could also be added to the video feed from the inquiry so that they'd be seen. There's actually an example of this in a previous case dealt with by DPA, and if anyone's interested, I can provide a link to that if they want to see how it worked. And the other point I wanted to mention under this was the inquiry protocol. That's what we're going to call it anyway. What we were proposing to do was set out a list of a brief list of rules for parties' engagement in the inquiry, to cover matters such as when proposed attendees should stay away, adhering to social distancing during the inquiry, wearing of masks, and so on. And as I said, we would run that past the parties and get their views on it before imposing it on anyone. Does anyone have any comment on that, or on the question of documents?
So just on the question of documents, it would be very helpful if the programme officer was to put up on screens, I think plural rather than singular, around the room if documents are being referred to. That might save time, certainly save fiddling around with hard copies, depending on how many people are or are not in the room. If there are any members of the public, I would have thought that would be very helpful indeed. And I would suggest more than one screen.
Yeah. Yeah, Mr. Steele, absolutely. Screens is what I meant to say. Yes, I think that would be the way to do it. Yeah.
So on the protocol, no comment at all. Obviously, that would be very helpful, and indeed probably a prerequisite to have such a thing.
Right. Okay, I'm not seeing anyone else wanting to comment, so I'll move on from this. Next item is any issues arising from reporters working with the programme officer. So I think we've discussed everything I wanted to say about this. So I will just give parties an opportunity to make comments on the role of the programme officer, and particularly whether they're content that a programme officer should be appointed, and whether they would find her role of assistance. Just well, perhaps I should say briefly, we see her as being of assistance in the preparation of documents for the inquiry, particularly coordinating the parties' common list of documents, in compiling the inquiry programme, and assistance of in presentation of documents at the inquiry. Sorry, Mr. Trinick, I saw you raise your hand.
Thanks, sir. Well, as you know, the Clash Gour applicant is a firm advocate of a programme officer, both for a virtual inquiry, which we hope is not going to be necessary, but also for a physical inquiry with social distances and operating under a protocol. We think that person really will help with document presentation, collation management, programming, also helping parties with queries that arise during the inquiry, assisting you generally, and obviously being impartial support, not acting for any one party, but reporting to you. We think that person is essential.
I should have covered that. Yes, indeed, the idea would be that they report to us, and I appreciate that it's the applicant or applicant that's paying for the programme officer, but she's given us an assurance that she would report to us. Anyone else?
So just to say that we and without going into any details, we're in direct contact with Clash Gour about the practical matters, which need not trouble us just now, but we are very supportive of this.
Well, that's very helpful. Good. I don't see anyone else wanting to comment. There is an issue which Mr. Trinick raised earlier about exactly how documents are handled. That's something we're going to look at internally. I'm going to speak to DPA management about that. So we'll move on from that. We're on to well, the notice of the meeting comes before the any other business. Perhaps it'll be better to cover any other business before making a final point on the note. Does anyone have any other business? I think.
Well, you haven't
actually, Mr. Kelly wants to make a. Oh, sorry, Mr. Trinick.
You haven't finished number 7, sir, about internet solutions.
Oh.
Other measures, stuff. Any other arising from measures to agree to address the pandemic. Just to record, I think we've agreed that you will ask parties, all parties, if any of them do need internet support, so that the Clash Gour applicant can get in touch with those people and attempt to provide that support. I think that's an important step.
Yes, I think that message should have gone out to, and I think it has gone out to the parties. I think it went out yesterday, the day before, just to say that if anyone who's participating in the inquiry does need internet support, who couldn't be expected to provide it for themselves, they should contact Samira and let the Clash Gour applicant know at the same time. Sorry, Samira, I see. Our case officer, Samir Akbar. All right. Anyone else want to raise a point on that? Nope. Okay. Any other business? I know Mr. Kelly raised a point about SNH. He wrote to us asking whether we were going to invite SNH to the inquiry. Our view is that we have extensive landscape evidence at the inquiry, and we don't see it as helpful to invite SNH to give further evidence. That's why we haven't done it. I'm very sorry if I didn't reply to you directly on that, Mr. Kelly, previously. But if you would like to come back on that.
Thank you, and I note your apology. Thank you for that. In the circumstances, it's likely just to be a submission point. Safe Wild Moray is of the view that ministers need up-to-date and comprehensive assessment of the applications, including, as they stand just now, including the cumulative position as it stands just now from SNH. But that is simply our view. Obviously, neither we nor you can require SNH to attend, so we just have to deal with it in submissions.
Mm-hmm. Okay. Thank you, Mr. Kelly. Does anyone else have any other business? I note in passing that we received correspondence, which I haven't had a chance fully to digest, from Cairngorms National Park Authority and RSPB Scotland in respect of our invitation that them to, if they wanted to appear at the inquiry. Mr. Steele, did you want to say anything about that?
Well, sir, a couple of points just before I turn to that. I'm not sure whether we get a response from Moray Council about the up-to-date local development plan position. It was raised earlier in this case conference, but is there an update on that at all? That's the first point. Second point, on Cairngorms National Park and RSPB, I received this sometime after 9 o'clock this morning. I have glanced at it, but have not yet had a chance to digest or look at it, but I have glanced at it. And I understand also that Save Wild Moray also wanted the Cairngorms National Park Authority to attend, but Mr. Kelly will speak for himself. But an important point to make about the Park Authority, sir and madam, is this, that there are no reasons or justification that we are aware of to support the objection that the Park Authority has taken, contrary to the clear recommendations of their officials. Therefore, we are at a loss to understand the basis for the objection, and they have thus far failed to explain it to us, and we would certainly wish to have the opportunity to ask questions to understand the basis of the objection. But I would prefer to respond to you in detail in writing about this, because this is a preliminary view. Insofar as RSPB is concerned, again, a preliminary view, but they seem to misunderstand the legal position, because there is a requirement to have an inquiry, which they don't seem to understand. And if they fail to attend, I indeed will make submissions that no weight should attend to their evidence, for we believe that it is misconceived and proceeds on certain factual errors. And we would again wish the opportunity to ask questions about that. Having said all of that, sir, we are mindful about the need to restrict the evidence and attendance as much as possible, but that of course must be balanced with the fairness that is required in the process. So again, this is a preliminary view. and I would welcome the opportunity to give you a full response in writing within a short period of time, say before the end of this working week, if that's agreeable.
Well, just before we move on to other people, and it's maybe I don't know whether this is raising a spectre or a matter of general importance. And perhaps it's something for you to consider in making your submission, Mr. Steele. But I'm slightly concerned about the idea that you know, if I should reach the or if we should reach the conclusion, or ministers rather should reach the conclusion that no weight should be given to someone who'd made an objection but did not appear at the inquiry, if no weight should be given to that objection because they hadn't appeared at the inquiry, that does seem a bit problematic, because there will be quite a lot of people who've made objections who aren't actually appearing at the inquiry. But perhaps that's something you can consider in making your submissions.
I absolutely take that point, but my immediate response to that would be that Cairngorms National Park Authority are in a different position. They are a statutory constitution, and in addition to which they have taken, as far as we can see, a decision without any proper basis for it, a decision to object, contrary to the advice of their officials, and without, so far as we are aware, any professional advice that would support that objection. That's not a unique circumstance, but it's an unusual circumstance. And I do say that we're entitled to understand what, if any, is the basis for it, or was it an error, or was it just bad luck that on that we were the third application being considered, and that the third one up was getting an objection. We simply don't know, sir. So it's rather different from other members of the public or others putting in objections, which in writing, which is entirely appropriate. RSPB is not precisely in the same position, but they are a body to whom great respect is accorded. And again, I would say that we are entitled to understand what their basis of their objection and whether it's properly factually based or not. But I hear exactly what you say, but these are particular circumstances that apply here.
Okay. Right. Well, I think that's as far as we can take until we see Mr. Steele's submission. Does anyone else have any further? Mr. Kelly, I'm sorry.
On this point of the Park Authority, it's a difficult issue, and I have considerable sympathy with the position set out by Mr. Steele. From my reading of the documentation, what Gavin Miles has said in writing to the DPA is not consistent with the minuted decision of the January Planning Committee of the Park Authority. And the Park Authority itself seems to be rather confused in terms of the members of the Park Authority seem to be rather confused as to what their position is. Save Wild Moray is also the view that the Park Authority is being inconsistent between these two applications and inconsistent with the actual sound position that's taken, for example, in Glen Sherrill. So as it might seem strange coming from someone who is objecting to the schemes, but we do agree with Mr. Steele that we want to hear what the Park Authority has to say by way of explanation for the different approaches to the applications. And I think it would be immensely helpful if they were giving evidence to the inquiry.
I just say I'm very grateful to Mr. Kelly for saying all of that, save for this, he's rather ruined my entire line of cross-examination.
Right. Okay, well, thank you for the helpful comments. We'll wait for Mr. Steele's further submission though on that. Okay, Mr. Oh, I'm sorry. It's Mr. Steele asked about an update on the LDP. I'd understood from Mr. Brown that was to be adopted imminently. Sorry, Mr. Brown, do you want to come back on that?
Yes, sir. It should be adopted in the next week or so. The intention is it should be adopted by the end of the month. So an update will be provided on that once it is formally adopted.
Right. Mr. Steele?
Well, it's nothing more.
Are you content with that?
If that's the information, that's the information. We merely wondered whether ministers had given any response at all yet, delaying, denying, or similar. But if that's the position, that's the position.
I know there's a period in which ministers can take action in respect of adoption of an LDP. That's not your understanding, then, Mr. Brown. No, there's no interjection by ministers in respect to the adoption process.
Not that I'm aware, sir. Okay. Instructions are it should be adopted in the next week or so. So I'm assuming there is no intervention.
Right. Okay. Just to be clear, I know I'm a reporter at the DPA, but I'm not aware of the process of Murray LDP. That's why I'm asking a daft question. Okay.
I think that
sorry, sir.
The 28-day notification of intention to adopt the plan has now expired, that period. So, and the absence of any objections from the ministers, then Murray are free to adopt. That's my understanding.
Sir, if I may, okay. I've now received confirmation from the council that the Scottish Government is happy with the LDP.
Right. Good. Okay. The last item is the note of the meeting. We're going to provide a note of the meeting as soon as possible. I'm afraid Mrs. Black and I are on site inspections the next few days, and I am then on holiday, so it's likely to be early the week after next. If we can do it this week, we will do our best to get it out, but it's likely to be the week after next before it appears. Ms. Trinick.
Noted, sir, but the real urgency is to get this draft timetable out so we know what we're doing. Yeah. I really would urge that that's done pretty quickly.
Right, we'll discuss that with the programme officer as matter priority.
So would it be possible to proceed, given there's going to be a week or two before you issue your note, etc., would it be possible for us to proceed with confidence on the basis that firstly it's Abbey Moor? I think the simple answer is yes, and secondly that the inquiry will extend over 3 weeks, because we need now to book accommodation, and holiday accommodation in Scotland in light of staycations is now not quite as easy as it once was, so we need to make practical arrangements immediately. So would we...
Yes, that's helpful. I think from the discussion earlier, yes, 3 weeks.
We'll proceed.
Yes, so just on the same vein as Mr. Steele was asking questions, that is it confirmed that if there is an overspill in terms of landscape and visual, that will go into the first couple of days of the third week?
I think that's something that will need to be dealt with in the programme. I'm sorry I can't give a firmer answer than that, but we'll discuss that with the programme officer as a matter of urgency.
So the other possibility. So the other possibility is, and I've now looked at Annex 4 and I now realise what actually the position was. So I was quite wrong earlier. But the other solution would be that we had Clash Gour's evidence first, and then the opposition to Clash Gour next. That would solve the problem. Any potential problem of Mr. Finlay, or indeed Mr. Welsh, would be resolved, because certainly the Clash Gour case for and against would be over, certainly in the first week.
Well, it's quite a big topic to raise at the end of the case conference. I saw Mr. Finlay had a point. I'll go to him, and then perhaps we can come back to that. Mr. Finlay.
Well, yeah. So it's really just simply, I understand that programming needs to be dealt with, but it's a matter of booking accommodation and the like. So the sooner that we don't have a particular view because we realise we're a small part in the wider inquiry, but in terms of just as soon as we can have certainty as to when we might be needed, that would be much appreciated. I certainly don't want to, I'm not suggesting a change in approach to the evidence, the order of evidence, which was, as I understood it, Mr. Trinick first, then Mr. Steele, then Mr. Brown, and then other people following on from him.
Mm-hmm.
And for my part, I'm not taking a view on that at the moment. I want to take soundings from my team, and I look forward to receiving the draft timetable.
Okay. Mr. Kelly.
Yes, the draft timetable is of critical importance. As I've said in other emails, my clients as a local self-funded group have extremely limited funds, and it would be a particular challenge for them if I had to be there in weeks 1, 2, and 3. It might be possible to dip in and out, I don't know, but as others have said, accommodation has to be booked, and there's significant pressure on accommodation. It would be immensely helpful if we could have a draft timetable within the next day or two, certainly this week, to allow us to book accommodation, or else it's going to have to be speculative bookings, which may or may not be needed. So I would urge, as others have done, that we get the timetable ASAP. Thank you, sir.
Right. Okay. Your position's all noted, and we'll deal with the timetable as a matter of priority. Okay. Does anyone else have anything further? Okay. Well, thank you everyone very much. Mr. Trinick, thank you. Mr. Trinick, you don't want to speak?
No, thanks, sir.
Okay, right. Okay, thanks very much. Well, I guess we will see each other in person at the inquiry. Okay.
Thank you.
That's the close of business.